G'day from me, John Denton, and welcome to another episode in the Business Ready for Sale podcast series. A topic that often comes up when I'm talking to business owners, particularly when they're looking to sell their business or get a value on their business. A topic that comes up a lot is intellectual property. Sometimes the business owner realizes they've got some intellectual property. It could be copyright, patents, trademarks, trade secrets, a whole bunch of things, and they want to know how that impacts the value of their business. And it's a very complex type situation. And the other time the question comes up is when I'm working with business owners to help them grow their businesses, scale their businesses, and they've created something and they want to know whether they should patent it or trademark it. Do you patent it in this country? Do you patent it in other countries or globally? There are so many options. I was fortunate recently to come into contact with Juan Perez from Quest Legal, who is an intellectual property lawyer. And I was so impressed with the information that he was imparting to a business association that I asked him if he would do a webinar on the topic for my clients and every business owner out there. He graciously agreed, and I've taken the audio from that webinar, and that's what you're going to hear now. The webinar did include a couple of handout documents, an IP checklist, and another document outlining all the different types of IP that you can have in your business. You will be able to find and download copies of those handouts if you go to my website and the podcast section. So go to johndenton.com.au/podcasts and scroll to the bottom and you'll find a resources section there where you can download the handouts for this section. So now let's go over to the audio from the webinar and hear what Juan's got to say. Welcome, everybody. Welcome and thank you for being here. For those of you who don't know me, my name's John Denton and I have a couple of businesses. One is Business Owners Taking Action and the other is Business Ready for Sale. More about those in a moment. Welcome to Juan Perez from Quest Legal. Hi, Juan. How are you?
Good. Thanks, John. Thanks for inviting me along today.
No, pleasure. I'll tell people in a moment how we come to meet and be doing this webinar. Business Owners Taking Action is a coaching business that I run where I work with business owners one-on-one, and I also work with them in a group process. And one of the things that I do for them is I get experts along to present on different topics that are valuable for business owners. And it was at a business association meeting some months ago that Juan was doing a presentation similar to this one and invited people to tell him what their business name was and then gave them some feedback on their business name. And he told me I didn't have a very good business name. So that sort of incented me to catch up with him after the presentation. But I was so impressed with the content of the presentation. I said, look, my business owners that I work with would love to hear about this. So that's how he came to be on this presentation this morning. And I'm sure he'll talk a little bit about that later. Juan, good morning again and welcome. Over to you.
Good morning. Thank you, John. And I should just start by saying that you took the feedback really graciously, John. So thank you. And it led to us connecting today. And we will go into a little bit about that and why you got that feedback. It's actually a good example, which we'll help to share around brand protection as well. So today my presentation is on the power of intellectual property. It's my favorite topic. And the reason it's my favorite topic is because intellectual property as a concept and as an area of law, to me, is the most fascinating area of the law. And as we go through the content, you'll get a feel for why it is so varied and it touches so many different aspects of business and life as well. Just a little bit about us. We're a firm based in Perth and Sydney. We have clients across the globe, throughout Australia and overseas. We do differentiate ourselves. We don't charge for phone calls, and we do fixed priced work. And the areas we specialize in are IP, commercial law, licensing and franchising, and technology law as well. And our why, which leads to our big, hairy, audacious goal, is to become Australia's best fixed price law firm. And that's leveraging the background, the corporate experience I had from my banking days. I'm not going to go into a big overview of my background because you can find that through LinkedIn or online. But a lot of the tricks that I picked up as I was working in banking and finance, tricks that apply to any size business. And we should make that accessible to the small, medium, and large businesses alike. So today we're going to cover 4 key topics. And they are, firstly, what is intellectual property? And secondly, what are the risks of your IP being stolen? Give some examples. These examples we're going to give are actually case studies on real matters that we have dealt with. In some cases, we've changed the names. In one case, the client actually allowed us to share the name, which is very generous of them. The third topic we'll go through is how can you protect your intellectual property? And then finally, what's the value this actually adds to your business? At the end of the day, the whole point of intellectual property is that it's adding value to your business and being able to help expand your business as well. So we'll just start with this poll. John, if you can help us run this, which is, the first question we want to ask is, do you think your business has intellectual property?
Interesting. We've got 90% saying yes and 10% saying not sure.
Great. Well, the simple answer to that is yes, all of you have intellectual property in your business. And as we go through a simple illustration of intellectual property, using KFC as an example, you'll understand why. The first reason you all have IP is you all have a brand. You have a logo. If you don't have a logo, at least you have a name. And sometimes that name might be your own name. But you all have a name. And as a result, you have a trademark. Now, most people think, well, I don't have a trademark because I've not gone and registered anything. But a trademark is just a name that you are using to run your business. Whether it's registered or not is another question. You all have written materials that you've created for your business. That might be promotional materials. It might be, for example, in the case of KFC, recipes, their 13 herbs and spices. It will be advertisements and publications as well. So you all have written materials. Well, that is copyright. And if you've met the minimum criteria for copyright material, then or for something to be subject to the Copyright Act, then it is protected by the Copyright Act. You may have bits of technology, or you might have products which are absolutely brand new to market, or a service that's brand new to market. It might be an invention. And so looking at KFC, they've got their own cooking processes. They also have their unique recipe, which they never patented, by the way. We'll come back to that patenting in a moment. But they that is actually an invention, and that is intellectual property. It can be a patent. It can be confidential information. There's different ways you could protect that. There's your products. You might have unique packaging with the way that your product is sold. Unique box. You might have a unique shape in the way that you've designed it. A good example of a good design, which would be protected potentially as a design, is this mouse that I had. It's probably one of the best ones I've had. It's a Microsoft mouse, and it's got a very clever design to it, which is it sits flat in my suitcase, yet when I go to use it, I just click it like that. That's a unique design. There's also goodwill and reputation. That's a key asset. And you think about then, if you've got a customer base, then you have a reputation out there. Some of you may not have a great reputation. Some of you have better reputation than others, but you still have a reputation. Well, that's all invest into your brand and your trademark. And finally, you may have processes and procedures, and they may be improved over time. Well, there's intellectual property in that as well. So most of you, I would have expected, if not all of you, will be able to tick the box to having one of those things in your business. Before I just jump to topic 2, I should say there's a concept with intellectual property you should all understand, and that is that often there's more than one way to protect intellectual property, and we'll come back to protection. But as a general rule, the more buckets of intellectual property you fall into, the better. So don't think of it as I only need one area of intellectual property and I'm good. The more you sit in, the more protection you have. And again, we'll get back into this as we go into topic 3. Okay, so risk of theft of IP. So let's do the next poll, John. Have you ever had an employee leave on bad terms?
Okay, the poll is now open. Yeah, it can be a problem. So we've got 76% said yes and 21% said no. So the majority of people, 3/4 of the people, yeah.
We could do another poll, but I'll save the time, and that is how many of you know that data was taken by that employee before they left. But I can say that in majority of cases, some level of data has leaked as they've left your employment. And that's just from our experience. So amazing that you just gave that example, John, because it's very much on point with the first case study. Again, this is a real life case, but we've changed the names. And that is Flex IT employs Sam as an IT technician for high-end clients. And Sam copies the files to the thumb drive and leaves the business. And our review shows that Sam had started a competing business while he'd actually been employed. So in this particular case, to make it worse, this particular employee was in the procurement department, and so was actually procuring products from his own company from his employer, and which essentially drawing a secondary income through that employer without telling the employer because they'd started a different named company. And he had control over that. And then Sam starts targeting Flex IT's clients, which obviously was a real concern for our client. How do you avoid a situation like that? And then I'll tell you what actually happened in this case. But firstly, protecting your intellectual property is important. We'll explain in a moment how you go about doing that. So I'll jump from that to employment contracts. Now, if someone steals your IP and your data, or they act in a way that's fraudulent, it could amount to a criminal act. But here's the reality of it, is the police is so absolutely busy with what they tend to do day to day that it doesn't take much for the police to not really show much interest, has been our experience. If you hit them with a fraud matter, they may investigate it if you're lucky, but it doesn't take much for the trail to go cold. And the reason is they generally, if they get a response from the other side of, no, I didn't, I was entitled to it, I was allowed to do it, then they pretty quickly categorize it as a civil matter. And then they'll just say, look, just take your own legal action. So
just while we're on that, Juan, can I ask a question? Like you were talking before about if somebody's on LinkedIn and they're building their contact list up on LinkedIn from a business's clients,
yes,
because then if they leave and jump ship and go to a competitor, they've got contact with all those clients. I mean, is there any, I don't know if there's been any cases, but it makes me think, well, who actually owns the contacts?
It's contact information is just publicly available information generally, in that, yeah, the fact that someone works at a particular workplace, there's nothing confidential about that. What is confidential is if someone's actually taken a compilation of clients' lists and just taken that with them. It becomes a bit more complicated in that example, John, because they've not done that. What they've done is they actually run with what they've done is they've actually had the list themselves, and it's just already publicly available information. So it takes me to a point on restraints and why an employment agreement is important, because then in an employment agreement, you can actually document very clearly what they are allowed to do and not allowed to do while they're employed. And that includes not taking or contacting clients, particularly after they have ended their employment. Now, that's a restraint of trade. Restraints of trade historically are very difficult to enforce. And that is because at law, there's seen to be penalties. And the law doesn't, the general law on this is that a restraint should not prevent someone from being able to earn an income, because that's their trade, right? But under the Restraint of Trades Act, and there's legislation in each of the states, you can actually, and it's been also codified in Commonwealth's law, you can enforce a restraint if it is of a level and breadth and nature necessary to protect the business interests of a particular business, the commercial interest of the business. So it needs to be of a reasonable nature. It can't be 5 years you can't work. And you can't work anywhere in Australia. It has to be drafted carefully and couched along what's reasonable to protect the business as well.
Yeah.
There were some good comments there just in the chat. And Kristen just mentioned the police did not have the resources for this type of case, unfortunately, particularly cyber information and data breaches, or where an internal person steals it. Yeah, and that's been exactly our experience with that as well, and our clients' experience. There is nothing better from an evidential point of view than monitoring your systems for data transfers. And that's where having access to a good cybersecurity firm, Kirsten's at one of those called Cyber Cerberus. He's also one of our clients, so thank you for joining us, Kristen, and with Tom. But monitoring your systems carefully so you have an evidence trail is very important, and so you know what's actually gone. And one of our clients actually had patient information. They're in the medical field. Well, they need to know exactly which patients are being impacted, because they'll probably need to notify them of that breach as well. Also, act very quickly. If you need to, you're issuing cease and desist, you're notifying clients. And in the case of this particular case study, it actually ended up in the courts. And particularly with an order to return data, and if need be, you can also seek injunctive relief, which is to actually stop them from using this information. So be prepared to initiate proceedings. In this particular case, the damage was controlled, although it was there, because our client was very proactive in going directly to their own clients and notifying of the issue, and then also initiating those proceedings quickly and getting a good outcome in orders against that employee as well. Okay, if we go to the next poll, has a competitor ever used a similar name to yours?
So 40% yes, 60% no.
Okay, that's actually more than I thought, because it happens a lot, but not quite that much. So it just shows that this is a real risk for a business. Before I start, thanks for keep the comments going. We are reading them as we go, and even the fact you love the mouse, this is my third one of the same mouse, so there you go. So in this particular case, this is actually a real case where the clients actually allowed us to provide the details, which is very kind of them. This is a medical centre called Forest Lakes, and they've been in business for over 20 years. And down the road, there's a shopping centre called Forest Lakes Shopping Centre. And a medical practice opened up there, and they called themselves the Forest Lakes Surgery. Now, we're the lawyers for the surgery. And what happened was we got a call, urgent call, saying that, oh my God, patients from the other clinic are rocking up to our clinic because they got confused. And more of an issue was that hospitals were starting to send private information to the wrong clinic, x-rays, surgery details, you name it, was going to the wrong clinic. Now, this is really serious from a privacy and data breach perspective. We'll explain what happened in that situation in a moment, but the first lesson here in how to avoid this is to understand an important concept when it comes to brand protection, and that is that registering a business name or a company name isn't enough. That requirement under the Corps Act is simply that if you trade under a name that's not yourself, then you have an obligation to register that name. So I could start a business called Juan Perez now and get an AVN for it because that's my own name. But as soon as I change it to be a Quest Legal, then I have to register that as either a company name or a business name because it's no longer my name. And the reasoning behind that is that if anyone has an issue with Quest Legal, they need to be able to look on ASIC's register and work out who's behind that business to be able to take action against them. Therefore, getting around a similar name on ASIC's records is actually reasonably easy. You could easily register Quest Legal, called Quest Lawyers, Quest Lawyers Australia. Just by adding some names around it, it's usually reasonably easy. Not always straightforward, but generally there's ways around getting your name, business name registered. As a result, a lot of people actually then complain to ASIC and say, how did you allow this to happen? And I promise you the answer you will get if you call ASIC is go and talk to a trademark lawyer because they know that the only way to actually stop someone using a similar name is to get it registered as a trademark. A trademark is, think of it as a patent. It gives you exclusivity not just over that name, but also over the similar names as well. And you can protect a name, you can protect a logo, you can actually protect the color, you can protect the smell. There's actually a number of unique things you can protect as a trademark.
Yeah, one didn't Harley Davidson patent the sound of the engine or something?
Yes,
there's something comes to mind with Harley Davidson and
and a number of the hotel chains have actually registered their scent, the unique scent you get when you walk into a hotel. Cadbury had a huge dispute because it was trying to protect the colour purple, and Dove, and there was a complaint, the issue there with the colours that were being used as well. So it's a very interesting area of the law. We've protected, you can even protect a shape, and we've protected shapes for our clients. And so this is where trademark law can intersect a bit with design law as well, because a design can be protected separately as its own form of registration as well. So we'll come back to that in a moment. Internationally, if you are trading overseas and you have customers potentially overseas, then you could be breaching someone's trademark overseas. And there was a very big case on this with the Upboot matter in the last 12 months, which actually led, because Upboot's now owned by a large international footwear company, and as a result, they took action against an Australian manufacturer which sold the UGG boot, labelled UGG boot, in the US. In Australia, it's still not protected by them, but it is overseas. Now, with trademarks, it's first in, best dressed. When you lodge your trademark, that's your priority date. So you need to get in first, and you then knock out your competitors if you get in first. If there is a breach like this, act very quickly. What happened in this case, we actually had previously registered the trademark for the surgery. And so we were able to issue a cease and desist, which was initially ignored until we actually called them and said, you've got to treat this seriously. If not, we will be issuing proceedings. They got a lawyer, and the lawyer actually, thank God, advised them correctly. And based on that, they actually had to change their name. Now, can you imagine then the amount of work they had to go through, which is rebrand, new signage, new promotional materials, and the embarrassment of notifying their clients when they'd only just opened a month before as well. And that is not a unique scenario. Only in the last 2 months, an IT company approached us and they had the same issue, and that IT company had to change their name as well.
Wow, that's a big expense if you've got to go through all that change.
It is. It's huge. It's very expensive and embarrassing. So if we go to the next poll, John, have you ever hired a contractor or manufacturer? While you're doing that, Kirsten asked a question, how does that differ when you have a parent company with different divisions within that ABN or ACN? If you have a parent company with the same name and then you've got sub-names and so forth, you can usually get that across the line more easily. It might come up as an objection, but then you can raise that with ASIC and they usually let it through. If you've got different divisions, you can still use similar brands across all of those. I think that's where your question is.
There's a lot of confusion I find with business owners between what's a trading name and what's a business name. And trading names will disappear off the Australian Business Register as of October the 31st. And if you want to know more about that, rather than hold up the webinar, you can go to my blog post on johndenton.com.au. Have a look at my blogs, and there's a post there telling you what you can do about it. But trading names will disappear. They're not an official name. Okay, so have you ever hired a contractor or manufacturer? 2/3 said yes, and then the rest are split between no or no, but I'm thinking about it. So, yeah, let's have.
So thank you. That's good insights. And just before we move on to that, there's a couple of great questions. John, if we can just keep track of those from Ron and Ace that have come through, I'll answer those at the end.
Yeah.
By the way, I could keep talking about this forever, so I'm going to have to probably speed up, or we could do a part 2 if we need to, John. In this particular case study, this is around IP ownership disputes, and we have a Smart Tech Solutions Proprietary Limited company which hired Tech Toys Proprietary Limited as a contractor to manufacture a new version of their robotic toy car. They had patented this in the past. Smart Tech understood they were paying for ownership of any IP that Tech Toys created. Tech Toys has started creating their own model of a robotic toy car based on their patented version, arguing that the only IP in their own version are only providing a license for Smart Tech Solutions to use their IP. Now, in this case, we do have the benefit of there being a patent, and we'll just elaborate on this a little bit more. A patent gives you exclusivity for 20 years over that particular invention. If it's a pharmaceutical product, it can be extended to 25 years. But that's it. That's what you've got. You can then potentially patent other developments that go past that. But because it has a limited lifespan of protection, this is why Some companies don't go down the patenting route. They prefer to keep whatever invention they've got tight-lipped as confidential, and think of that's what Kentucky Fried Chicken did as an example. KFC didn't patent their recipes. They just kept them as highly guarded secrets. And you can do that via keeping information in vaults, by limiting the amount of people that can access it, by having those people that do sign that are subject or have access to that information to ensure they sign confidentiality agreements as well, and be prepared to enforce them as well. But in this particular case, you have actually a patent, and this contractor's gone and done some manufacturing work and basically stolen it. What you have in your manufacturing agreement is actually quite important. Now, if you've got a patent, you've got protection, but it is important to be very clear in your agreement that if you are in a manufacturing agreement, if there's any development made of that as you manufacture, because you go to a manufacturer potentially for the first time, they may say, oh, we can do it this way or we can do it that way. And that approach they do, the manufacturing, can in itself have intellectual property as well. The position at law is if you create it, you own it. So think of a photographer that comes to your wedding and starts taking photos for you, and you pay them $3,000 to take those photographs. You might think you own those photographs, but you actually don't, because the photographer actually clicked the button, used the technology to actually create the image, actually own the copyright in those materials. And in this case, it's not dissimilar. The manufacturer actually created a particular process to be able to manufacture this, and may actually own that process if it was a unique development in its own right. So the only way to ensure that that's properly transferred across is to document it. Now, that position is different if you have an employee. If someone is employed by you and they're doing works for you, then that intellectual property, the copyright, is owned by you as their employer. But if they're an independent contractor, then you do have to be extremely careful. Now, think about those who have developed a website for you, those who have developed your logo. Think about anyone that you may have brought in generally as a contractor because you just brought them in for a particular unique task. A copywriter, for example, of your materials, people producing your publications, they own your IP that you think you own. What you have is a license to use it, because otherwise, why would you pay for it if you couldn't use it? So automatically you get a license to use it. But some of you might be surprised that you don't actually own the IP. And the only way to fix that is to actually document that as well. So
if somebody creates the logo for me, they own the logo.
Yes, that's right.
Wow.
Yeah. Under license, but I get asked this question a lot, and I always ask them to send me the contract in place with the developer of that logo to look at the IP clause. Hopefully it has an IP transfer clause. But in my experience, most don't. So they don't own it.
Another one, if I supposing I create a training course or a program for Department of Silly Walks or something like that, they pay me to create that training program. Because I do walk silly sometimes. So they've paid me. I've created the training program. Who actually owns the training program?
You own the program because you created it. And
because I created it, so I can sell it to somebody else.
You'd have to remove anything that's obviously proprietary to them, because there is this concept of co-creation of IP, because they may have given you a lot of the core information for it. So they will. It may be that they own the background intellectual property for it, and you own the end product, or there could be, if it's been prepared in collaboration together, is actually joint ownership of intellectual property. We're dealing with a reasonably large client at the moment who I don't have consent to disclose, but they have jointly created intellectual property with another party and didn't document all their agreements effectively. Now it's a negotiation on who owns that IP. So avoid that by being clear and upfront at the very start. So in this particular...
Get you to do an agreement before you start the process.
Exactly. Now, in this case, we were able to rely on the patent. So thank God we had the patents in place. And the particular manufacturing approach wasn't really that relevant. So we were able to stop them from proceeding and came to an arrangement with them. But and this one didn't end up in the courts, but it can very quickly end up in the courts. So if we bring all this together now into topic 3, how do you protect it? You're already getting a snippet of this from these case studies, but and the overview that we're going to give you at the end of today is actually going to flesh this out in a lot more detail, and I'll quickly show you an image of that in a moment. But we have a brand name and logo. Well, you protect it as a trademark. It gives you protection for 10 years, and that can be renewed. So you can also seek international registrations, and you can do that by going directly to those countries, or you can do that via protecting via what's called the Madrid Protocol, which allows you to lodge an application with the World Intellectual Property Office, and that can all be done by an Australian lawyer or Australian trademark attorney from within Australia, and it gives you the rights back to the date that you registered in Australia internationally. And there's more fees, of course, that apply to that, but you can register internationally more easily as a result of that protocol. Now, on this, I'm going to use you as an example, John, and your name, if that's, is that okay, John?
Yes, go ahead. It's fine.
Thank you. He's got broad shoulders. Okay, so John's name is Business Ready for Sale. Now, when you select a name, there's a friction between selecting a name which is descriptive and gives you instant recognition of what that is. And that name does that. Business Ready for Sale indicates very easily what it is that you're trying to, what service it is that you are offering. And that can be very helpful, particularly when you're new to market, because you don't have to do too much to educate your audience on what you do. On the other side of the spectrum is a name that is so nebulous and so unclear as to what you're providing that you have to explain it in detail. And those names are generally easier to protect, though, because a name which is Business Ready for Sale is so descriptive that the Trademarks Office will just not let that get across the line. And the reason is, why should they give you monopoly over a name that includes business ready when others should be able to use those common terms in trade? They don't want to restrict others from using very common terms. Some names which are very generic and broad can be protected, but you have to have been in the market a long time. Think of names like Budget. Well, they're protected. But the way they got across the line was they'd been in the market for so long that they actually became synonymous with that name, and that service became so synonymous to them that they should get exclusivity, that no one should actually ride on that goodwill that they have spent so much time and money generating over the years. And the way they had to get across the line with that was to provide significant evidence of use to show that it's been used have to be across the market. And generally, you have to give at least 3 years, preferably 5 years or more of evidence of use to get those across the line. So for you, John, if you said, I want to register that name, I'd say good luck. I'm not even going to bother trying. Unless you tell me you've been using it for 20 years across the whole country, it's just so generic for that reason as well.
Fair enough.
But that doesn't. But look, if you don't care about that, then that's great. Just keep using it. There is a flip side to this, though. If you use a generic name, and it goes to one of the questions that was raised there by Ron Delia, which is, what about if you are on the other side to make sure your business name has not already been used? Well, the more generic a name, the more likely it is someone has used a similar name. Well, that's the risk that you run. If they manage to get it trademarked, then you might be on the losing end of that fight as well, if they've been out there for a long time. So generic names are a bit dangerous for that reason. I'll give you the example of the very best sorts of names, and they're names that allude to what you do without actually saying it. And a perfect example of that is Flick, Flick Pest Control. It doesn't say we kill pests, but that's what you do to pests. You flick them away. And what a great name to come up with. So if you're looking at naming, that's something you should consider as well. If I jump then to the next one, written materials, copyright. Basically, if it's an original work and not a substantial reproduction of someone else's work, you automatically get protection under the Copyright Act. But here's the trick with this. Most people think, well, I didn't put the copyright on it, the C symbol with the circle around it. It doesn't matter. You automatically get protection. But it is good sense to do that anyway, because you're notifying the public that you are treating it as copyright. So don't copy it. Is basically the signal that you're giving. A similar point on that, just back to trademarks, everyone can use the TM with a circle around it on their brand, because you're just telling the world that you're using that as a trademark. But once it's registered, you can use the R with a circle, but not until it's registered. So just be aware of that in your business as well. I already touched on patents as well. One of the questions that was asked leading up to this was, if you're trading overseas, do you need to register a patent? Does it give you exclusivity in relation to that particular product or invention? Absolutely, it gives you exclusivity for that period of time, as I mentioned before, 20 or 25 years, depending on what it is. And if you want to protect it overseas, if you want to use it overseas, then you also have to protect it where you want to use it as well. That's a whole big topic about international protections as well, and we are running out of time. But as a general rule, you've got to protect it where you want to use it as well.
There's a question from Helen there on copyright while you were talking about copyright.
Yes.
Good question. Who owns copyright when a public presentation is videoed with permission of the presenter?
Yeah, the person who videos owns the video. The presenter owns the content of their speech and what they wrote. But that doesn't mean that the presenter can't say, well, I didn't give you consent to video you. You can require that. But assuming there's been consent, then there's an issue there as well. Are intentionally misspelled names like tooth fairly easy to trademark? Well, the Trademarks Office does look at phonetical similarities as well. So if you called yourself Tooth Dental or 230, you probably would run into an issue because they look at phonetical similarities as well. A name like that, I would mix it in with a logo, because logos, the graphical embellishment can give it a bit more distinctiveness. So it doesn't mean you couldn't protect it. It's just more likely to get an objection as well. But there are techniques you can use to avoid that. Quickly, designs. So like I mentioned before, that's got a unique design to it. You can protect that unique design. Think about it this way. The Coca-Cola bottle has got a very unique shape. Well, that's protected as a design so that you don't see other Coca-Cola bottles with that type of shape. The contents inside it are protected as a patent. If they are protected as a patent, most of these ingredients are actually protected as confidential information, not patented. But what's inside is the invention, and what's outside of it, the branding, is the trademark. So that's a good illustration. And you look at the label on the back of the Coca-Cola, all the material that they've written there, that's all copyright as well. So in that bottle of Coca-Cola, you've got at least 4 or 5 types of intellectual property, as an example.
Okay.
We'll jump ahead because I think we've covered the major ones here, and we revisit with other assets, brand reputation, processes and improvements. That jumps into trademarks, patents, design, and confidential information as well. So we're going to get to the cut to the chase now, and we'll finish up in a couple of minutes. But why is this valuable? It's valuable because at the end of the day, it might actually be what adds the most at the bottom line when you go to sell your business. Think of big companies like Apple and Microsoft. They've actually valued their intellectual property, their intangibles is what they call it on the bottom line. Apple at US $2.2 billion, and US and Microsoft $1.5 billion for their intangibles. That is huge. Representing approximately 20% of the value, the whole value of the company as well. Yeah. Go on, John.
I was going to say, because one of the questions I had emailed in from someone who couldn't attend live was, to what extent is the IP value of a business already accounted for in the overall market value of the business? So I'm not sure if you can answer this, but businesses generate goodwill. So when we value a business, well, as a broker, when we value the business, then there is a portion which is the intangible, which is the goodwill.
Yes.
So how much of the IP would be incorporated in that? And is it possible to separate them out?
Often the two go hand in hand. Most of you who are involved in business valuations or selling or selling of businesses will know that different businesses in different industries will attract different multiples of EBITDA when you go to sell the business. So generally, in some retail businesses, you're looking at 2 to 3 times EBITDA. IT businesses can be well in excess of 4 or 5 times EBITDA, which is annual earnings essentially. Annual profit, not earnings, annual profit. In insurance at the moment, we're seeing multiples of between 3 and 5 times, which means that if in a year your profit is $1 million, then you can sell your business for, if it's 3 times, then you sell your business for $3 million. Now, what is the goodwill associated with that? How do you calculate that? Well, the goodwill is made up of what is left after you take into account all the tangibles. The tangibles being your equipment, any of your work in progress, values of existing contracts. All of that are your tangibles, things that you can really put your hands around, whereas what's left essentially is your intangible. And the value of your that is what you see when you are in the companies that are on the stock exchange, the different stock exchanges around the world. The value of the intellectual property, as the business starts generating greater and greater reputation, the value of the stock goes up. That's often associated with the brand value of that company as well, but also the announcements they are making of where they're going with their business into the future. So in answer to that question, it's generally what's left behind after you take into account the tangibles. And is there a difference? Goodwill tends to be the concept that's used for that balance, which is used to essentially calculate what the intellectual property element is, John. But goodwill also tends to wrap in the customer base as well and how much repeat business they're likely to get. So if you can separate that component out, then the remainder is the intellectual property value.
Yeah, and I mean, you're going to talk about franchises, and that's an interesting one because the value in a franchise is all about the brand, isn't it?
It is. And this is, and I know I'm running out of time, but a perfect example of your intellectual property going to the next level is a business that has become so well established that they know how to turn their business into a cookie cutting exercise. So take McDonald's, they developed the formula for how to be able to train other business owners to do exactly what a McDonald's store does, how to make a burger in exactly the same way and be able to turn it into basically a money-making operation. And if you follow these unique steps, then you will make money. And how do they do that? Well, they work out the process of how to do that, and they have the same branding, and that branding has to be protected as a trademark. Can you imagine if you went and spent millions of dollars buying a McDonald's franchise only to find that someone said, well, you're not allowed to use that brand because it's a breach and you have to rebrand all these franchises? At the very core of franchising is a license of a brand, but it's also licensing of copyright, which are all these processes and procedures, potentially licensing of unique recipes associated with that, which may or may not be patented. So you can start to see how IP can start getting value. Now, intellectual property in franchising, the way it's often set up is, and again, we're getting more and more into the details, so I'm not going to spend any time on this, but this is a standard structure used for franchising. And you'll see that in most cases, the IP is held separately. And the reason it is because it's seen as the most valuable asset in that system. And it needs to be protected from the franchisor company and all the franchisees underneath it, and licensed to all of those entities as it's needed. And if any of those entities get into trouble, then that IP holding company can terminate the license and it can continue to operate and own the brand without losing it. That's how valuable IP can become. So if you can just put in your chart any of the key takeaways from today, we'd appreciate it. But in the few minutes we've got left, John, do you mind just guiding us to some of the questions we may have missed along the way?
Yeah, there's a comment there from Ace. I don't know if you've seen that.
Ooh. The reputational risks with these scenarios could sometimes outweigh the monetary one, which could be harder to recover from when losing trust. And thanks, Ace. And it was such a joy to see that, Ace, you were joining us today. Ace is a lawyer at SBS who's actually worked with our firm for a couple of years. And it was really, we love Ace very much. So great to see you. It's a great point, and that is that if you find that you have to change your brand because you were sloppy and didn't protect your trademark, then that doesn't look good. So a trademark, as an example, it's not just trademarks, it's other IP, can be used as both a sword and a shield. A sword to stop others using a similar name. Why should they ride on your goodwill? You spent all the money on marketing and advertising. So protect yourself. Stop them being able to use it like the medical practice did. Or as a shield to be able to block someone saying to you, hey, stop using that brand. Well, if they do, you can say, hey, I've got the trademark. Just leave me alone, especially if they've come in from overseas and trying to muscle their way into your territory. John, any other questions that were not followed?
Yeah, I've got a couple of questions here that were emailed in. Whilst we go through those, I've just made available your handout for people, The Power of Intellectual Property, Summary of IP Types, which is a really nice, succinct and informative document. So you can click on that and download it.
John, given we've only got a couple of minutes, perhaps instead of trying to answer other questions, what I'm happy to do is any ones that haven't been answered, we can answer and then distribute to everyone so they can get the answers. But can I just talk to that handout so people know what it is that they're seeing? The list that we set for today was an opportunity for you to be able to go through and identify whether you have IP in your business, so that you can develop your own roadmap for protecting your own intellectual property. But what we're now sending to you is actually the keys to how to identify what that IP is and how to protect it. So we go against each of the different categories and we flesh out the previous slides that we went through. We flesh them out in a lot more detail on what is each of the categories of IP. So I hope you find that information valuable. And feel free to reach out to myself or the team as needed. John, I'll just run to our details. Here's our contact details. Feel free to please contact me directly or any of my team. Given it's 12 o'clock, let me thank you for having me along, John.
That's all right, Juan. Is it okay if I read those details out for the podcast?
Sure.
So it's Juan.Perez, that's JUAN.PEREZ at Quest, QUEST legal. So Quest Legal, all one word, .com.au. And what about your phone number? Do you want me to put that up or go to your website?
No, you can pop that up, 0411 588 558. And our website is questlegal.com.au.
And if you're listening to this on the podcast version, then those handouts that we've talked about will be available in the show notes. So you can get copies of them there, or you can contact me or Juan, and we'll give you copies of those. And if you want to contact me, it's john@johndenton.com.au. It doesn't get much easier than that. So yeah, there's not much else to say. That was fantastic. A lot of good questions, a lot of great information. I'll think about changing my business name. No, I won't. Because I've got two anyway.
If no one's giving you a hard time, just keep going.
One quick question. Is there a time when if I've already sold a product or put something into the marketplace and then I'd suddenly decide, I should have patented that, can I do it retrospectively?
Yeah, unfortunately, you've got to get in with patents before you go to market. And that's why any disclosure of any invention needs to be carefully guarded with an NDA, a non-disclosure agreement, as well, because a publication of a material could kill the novelty element of your patent as well. So again, new product, be very careful. New service, be very careful.
Thank you, everyone. Thank you for being here live. Thank you if you're listening to this on the recording or the podcast. And if you need any more information, contact Juan or myself, and we'll be happy to follow up with you. Thank you, everyone, and bye for now. Wow, that was a lot of information, a lot of really great stuff. I hope you got a lot out of it. It will certainly help if you download the handouts as an IP checklist to see if you're protecting the IP that you've got in your business. And there's also a document that outlines all the different kinds of IP that you can have. I recommend that you download those. You can get those from my website and go to johndenton.com.au/podcasts. And if you want to contact me, feel free to send me an email at john@johndenton.com.au. I look forward to having you on the next podcast.